Well, ladies and gentlemen, my name is Carl Stitchin, and I'm the director of the Institute of Advanced Legal Studies. It gives me a great pleasure to welcome you here for this very special event in this year's Institute calendar, the launch of the new book, English Arbitration and Mediation in the Long 18th Century, by Professor Derek Roebuck, Dr. Francis Boorman, and Dr. Rhiannon Markless. The Institute is very proud to be associated with this important piece of research, about which we will learn more shortly. But before we begin, I want to give a special thanks, give my thanks, to all those who have supported the project through their generous financial contributions, which has made this research possible. Your ongoing support of the project, of the Institute, our research agenda, and indeed our transformation project for the refurbishment of this building, which is, as you may have noticed, is ongoing, but on time and on budget. Your support is greatly appreciated. There will be photographs taken this evening. If for any reason you're uncomfortable with having your photograph taken as part of the audience, please do let our photographer know if you have outstanding warrants or anything. But otherwise, without further delay, I would like to introduce Ms. Carol Nairn of Scann Arbs to introduce the project and tonight's program. So welcome.
Thank you very much, Carl. Welcome everybody to the launch of English Arbitration and Mediation in the Long 18th Century, this marvelous book. And we're not just celebrating the launch of this book, we're actually, of course, celebrating really an entire series of amazing books by Professor Derek Roebuck. And it gives me great pleasure to be able to formally open and launch this wonderful book and to talk to you together with two of the co-authors of the book. We have Dr. Francis Boorman here, and we have Dr. Rhiannon Markless here, who wrote the book with Derek. And sadly, Derek can't be here today, but it is being videoed so that he can witness, at least at home online, the launch of his book, but also enjoy your reactions to hearing a little bit about the research and the contents of this wonderful publication. Now, the earlier books, and this is the fifth book in the series of books about English arbitration, the history of English arbitration, and many of you in the room will have some of the marvelous earlier books. The book on early English arbitration, the book on mediation and arbitration in the Middle Ages, the Golden Age of arbitration under Elizabeth I, and then arbitration and mediation in the 17th century. And so this book is the fifth. And in many ways, of course, when one thinks about the 18th century, it was a pretty action-packed century. There was so much going on. I mean, we think things are exciting with Brexit, but it's just nothing compared to the drama of the 18th century, both political, economic, social, massive upheavals, as you all know. And what's really interesting about this book is to look again at the 18th century through the prism of arbitration and mediation, and to see that century in a very different way. And so this book is important on a whole number of levels, and as Carl said, it's been made possible by a special project, the Access to Justice project, and many people in this room helped to sponsor that project. And when you read this book, you will be very proud that you did. So I'd like to thank those people who have contributed, and I warmly endorse the book. But that's enough from me. I'd like to turn to the two experts on the book who spent a lot of time researching and thinking carefully about it. And we're going to start with a presentation by Francis, giving us a little glimpse into some of the themes of the book, and then we'll turn to a Q&A, and you'll certainly be welcome also to ask questions. So without further ado, I hand you over to Francis.
Thank you, Carol and Carl, for the very kind introductions. And I'd just like to reiterate what a shame it is that Derek couldn't make it tonight. He has been a great friend and mentor over the course of researching this book, and being a research assistant for him beforehand, and he sent me a short note that he just asked me to read out quickly at the beginning. So this is from Derek. He just says, this is to send all good wishes for the launch of the book, and thanks particularly to Francis, Rhiannon and Carol Nairn for the part they are to play. Though I can't unfortunately be there physically, I am certainly there in spirit and beaming full support from Oxford. I'm impatient too for a report of what I know will be a success. So those were words from Derek, and I hope now that I can, with my own words, do some justice to the research that we've been doing together with Rhiannon for the past few years. I really wanted to start by giving some justification for all this indulgence in history, as we are indeed in a law institute at the moment. And even if Derek's great series of books should speak for itself, I sort of wanted to offer something by way of explanation. But rather than make any outlandish claims for the usefulness of our book myself, I thought I'd rely on the historian's trick of choosing some outlandish claims from 18th century writers and looking a bit more at their approaches to the history of arbitration. So, firstly, Bishop Gilbert Burnet's posthumously published history of his own lifetime, covering a rather interesting period of the Civil War, Commonwealth, restoration of the monarchy, and the Glorious Revolution, gave a very grand justification, which suggests we might be in need of something similar in our own tumultuous times. Burnet hoped, he wrote, to give such a discovery of errors in government and of the excesses and follies of parties as may make the next age wiser, by what I may tell them of the last. Writing much later, in the early 19th century, James Mill's History of India was written in a Benthamite spirit of didacticism, which is surprisingly similar to Burnet's stance. The message in one of his assessments of the English presence in India in the 18th century is not hard to spot. He wrote, if they had inclined to act the part of really useful and pacific neighbours, they might have arbitrated between the parties with decisive and happy effect. Where 18th century historians did find societies using arbitration, it was generally seen as a sign of high status and indeed good sense. To pick one example, Edward Gibbon wrote in Decline and Fall of the Roman Empire, first published in 1776, that the Roman name was revered among the most remote nations of the earth. The fiercest barbarians frequently submitted their differences to the arbitration of the emperor. Historical example was not only for lofty academics. Elizabeth I's preference for arbitration was discussed in the newspapers as late as 1729. And history was also used to suggest policy. Thomas Mortimer, a writer on trade and finance, called for a return to the practices under Elizabeth I and James I of, as he put it, reputable, disinterested merchants acting as arbitrators in wage disputes. Returning back to Bishop Burnet, his history contains some advice on legal education, which included the suggestion that young men spend time studying the law with a practicing lawyer, thus avoiding what he considered to be the idle and vicious life at the Inns of Court. Competence in the law, he wrote, makes a man very useful in his country, both in conducting his own affairs and in giving good advice to those about him. It will enable him to be a good justice of peace and to settle matters by arbitration. Notwithstanding his advice on legal education, I think that quote leads us on to the actual practice of arbitration and mediation in 18th century England, and it also raises some of the questions that we really tried to answer in the book. What was arbitration used for, and by whom? Who were the arbitrators, and what relationship did the whole process have with the law? But first of all, what actually happened at an 18th century arbitration? The basic structure was in fact well established by the 18th century, and it went a bit like this. There were two parties in dispute, let's say two merchants. One had sent a shipment of wine to the other on credit, but they then disagreed about the quality and therefore the price that should be paid. Rather than begin the costly and slow process of litigation, they could instead agree to arbitration. Each merchant chose an arbitrator who might be a friend or colleague. In our case, they would naturally appoint other merchants with experience in the wine trade. The parties then generally signed arbitration bonds, of which you can see an exemplar behind me, and that obliged them to forfeit a sum of money if they did not comply with the decision of the arbitrators. The two arbitrators then attempted to come to an agreement over all matters in dispute. They might take into account an entirely separate outstanding debt between the merchants. They would hear any relevant evidence from witnesses and examine accounts at meetings that were often held in taverns, but let's have ours in the rather finer surroundings of the Merchant Vintners Hall. See pictured there. In the scenario of the wine merchants, the arbitrators would no doubt have the arduous task of tasting some of the wine. They then made their award, or if they still couldn't agree, another merchant was made umpire, and his decision would be final. For our merchants, he might order a price for the wine and also say when the money should be paid, perhaps in instalments. So that could be an entirely private procedure without the enforcement of courts or even the input of lawyers. But returning to that book of advice for merchants' apprentices, published in 1703, it certainly made no mention of lawyers when explaining the arbitration process, and included the example of a bond with figures missing that could be filled out by a layman. However, of course, the arbitration could be registered with the courts, and that brings us on to the Arbitration Act of 1698 and the Rule of Court Procedure. So the Rule of Court Procedure, in which the various courts accepted submissions to arbitration and made them rules of court, long predated its formal recognition by statute in the Arbitration Act of 1698. Rule of court became the standard procedure from about the middle of the 17th century. The Arbitration Act of 1698 was then designed by John Locke to give legal force to the existing procedure of having a submission to arbitrate entered as a rule of court, or by arranging an arbitration and then entering the outcome, the award, as a rule. Courts could also refer a suit that had already been commenced to arbitration, and Locke explicitly said that the Arbitration Act was to smooth the functioning of trade. The great jurist William Blackstone later described its effect, writing, "All merchants and others who desire to end any controversy for which there is no other remedy but by personal action or suit in equity, may agree that their submission of the suit to arbitration or umpirage shall be made a rule of any of the King's Courts of Record, and, after such rule made, the parties disobeying the award shall be liable to be punished as for a contempt of the court." When it accepted the submission, the court would appoint the arbitrators after asking the parties to suggest names. Depending on that court's practice, it might appoint one judge or members of the jury where the matter was being heard at nisi prius, or merchants to deal with disputed accounts, as we've seen. Once the arbitrators had declared their award, the plaintiff would enter judgment. The defendant's consent was taken for granted. The award expressly declared that it was final, not subject to appeal, and that no relief against it would be allowed in equity. Common law judges refused to hear arguments that such an award had been made in error. A Chancery Court might consider the merits of an award made under its own rule of court, but would then enforce it by decree. And just to give you a real-world example, this image shows an agreement between the widow Mary Guide of Rodborough in Gloucestershire and a woolen draper Samuel Morrish of Bristol to abide by the arbitration of a merchant and upholder, and those arbitrators were both from Bristol. Now, not all arbitration awards or agreements would be printed. The two I've chosen have been, just to make them a little clearer, but a lot would have been written out by hand. Yet another Bristol merchant is appointed the umpire in this situation. They agreed that the award will be entered as a rule of court at the King's Bench, and the award explained that they had entered into bonds of a fairly large sum at the time of £100. The arbitrators eventually awarded that Guide pay Morrish a mere £2 2s, and upon receipt, the parties exchange and release and discharge one another from all debts, bonds, suits, actions, and a full list of other legal obligations. This is a classic reciprocal exchange for an award, where both parties are giving something up, even if it's just a promise not to continue the dispute. So what then were the reasons people turned to arbitration to settle their disputes? The four most usual reasons to arbitrate, identified by James Oldham, were speed, economy, informality, and finality. Oldham also lists the choice of arbitrators, particularly experts, confidentiality, availability of discovery, and ability to handle complex cases. I would also add accessibility, both in terms of physical proximity, but also linguistic understanding. In the first case, you could choose an arbitrator who lived nearby, and therefore might be much easier to get to than the courts. And in the latter, they did not need to use any legal jargon, and might also be comfortable with regional dialects, which was a serious consideration. Of course, the social conditions in which people started disputes, and indeed had to resolve them, were always changing, making reasons to arbitrate change, and also the process itself. Merchants often relied on arbitration, as we've seen, for fast and equitable decisions that did not disrupt business relationships. In 1789, an impartial tradesman, as one correspondent to a newspaper styled himself, asked the public advertiser to reprint a letter entitled Advice to a Friend Against Going to Law, which described the law as, to quote, grievous and destructive. The letter said that after squandering time and money on lawyers, the recipient will be glad 7 years hence to leave it to that arbitration, which now you refuse. In many areas of business and industry, arbitration was vital in complex disputes. In the case of Wilkinson v. Wilkinson, and you can see a coin here minted by one of the brothers, the two brothers, John and William, had invested nearly £500,000 in ironworks around the country. One brother brought an action for damages for breaking up one of the ironworks. When he applied to the court to move the venue from London to Salisbury, Lord Chief Justice Kenyon, after hearing that the Guildhall could not hold all the witnesses, said he might never be able to try the cause, not least because both parties were of good character. The brothers also had several bills in Chancery, each containing several thousand sheets, and Kenyon, perhaps surprisingly echoing the impartial tradesman, thought the Chancery case might take over 150 years to conclude. He advised placing all the disputes before an arbitrator, which he described as the most unfettered judge in the world. The parties agreed to refer to the arbitration of several ironmasters of their choosing in 1795. The need for expert understanding was another reason to appoint an arbitrator. Architects and surveyors were routinely appointed in disputes concerning construction or land. New technologies arising during the Industrial Revolution made legal judgments especially difficult, without the benefit of expert advice. A newspaper report of Peyton v. Herring, a King's Bench action for breach of contract, described how the defendant had supplied a 7-horsepower steam engine for £330, but that its output was far below the promised level due to its defective design. 1 horsepower was estimated at £240 of force, that is, but the famed barrister William Garrow, to quote the newspaper report, here admitted that he was not in a condition to prove that this engine was of the power of 7 times £240, and so he said that a verdict should be taken on that part of the case with the quantum of damages referred to arbitration. Now, I have noted that accessibility was an important advantage of arbitration and mediation over litigation, not just in terms of cost, but also physical proximity. Justicing notebooks show that justices of the peace, some rather insalubrious ones pictured here, were called upon to settle large numbers of disputes, particularly in new industrial centres of population where there was a burgeoning need to resolve conflicts, but no concomitant growth in the state machinery to do so. An expert in law may or may not have been preferable, but the role of the JP in the local community, compounding everything from assaults to labour disputes, was very likely to be held by a clergyman or landowner. Standing in the local community and the aura of holding public office were their only consistent qualifications, and were enough for others to look to the JP. Take, for instance, Edmund Tew, born in 1700 and fourth son of George Tew, rector of Loddington in Northamptonshire, and his wife Mary. Edmund graduated from Jesus College, Cambridge in 1719, becoming a fellow there in 1722, and was ordained in 1724. In 1735, he became rector of Bolton in County Durham and stayed there for most of his life, being appointed a JP in 1750. Tew was one of an increasing number of clergymen acting as magistrates, with the number on the bench in County Durham doubling by 1800. Most of his business came from industrialising areas with rapidly growing populations, like nearby Sunderland and South Shields. Tew kept a notebook in which he recorded over 1,000 matters that he dealt with between 1750 and 1764, and of those 1,000 matters, only 18 ever went to trial. The first entry is a good example of the way that he worked, and he simply noted, 16 November 1750, James Colvin, weaver, swore the peace against Ralph Atkinson of East Bolton, made them friends, and James Colvin released. There are many warrants for assault, or sometimes just the threat of assault, nearly 40% of which Tew disposed of with agreed or simply noting down the letter A. He was clearly an enthusiastic and expert mediator. The writer and moral reformer, the Reverend Thomas Gisborne, actively promoted the informal role of the JP. The magistrate is most useful and best promotes happiness, Gisborne wrote in the book, the cover of which I've got up behind me, when he acts as a peacemaker, when he removes secret animosities, puts an end to open quarrels, prevents embryo lawsuits by a reference to private arbitration, and unites the jarring members of the same family in an oblivion of past misunderstandings and a renewal of concord and harmony. In a note, Gisborne warns against compounding differences where the law of the land or the public good requires punishment of the offender. This admonition to stay within the law seems telling and suggests that while it may not be desirable, it was not in fact unusual to arbitrate or mediate, even where the law demanded prosecution. The emergence of the petty sessions in the 18th century points to the lack of access to higher courts, and even JPs were not readily available all the time. In select committee evidence following the Cotton Arbitration Act of 1800, which was the next legislation to explicitly set out a process of arbitration after 1698, so fully 100 years, the cotton manufacturer Joseph Horrocks told that he was lucky enough to have a JP a few hundred yards away to settle disputes, but when pushed to speculate on the cost if the JP had lived 15 miles away, he guessed at, quote, 3 half-crowns or half a guinea to settle it at that distance. A man must be paid for going so far. The issue of distance was raised repeatedly during the hearings. Bolton warehouseman James Holcroft complained his nearest JP was usually 5 to 6, but sometimes 10 miles distant, and getting them to examine workmanship to settle disputes was, to quote again, very inconvenient to both parties. The inaccessibility of even a JP to arbitrate or mediate tells us that there were probably sections of the country in which arbitration remained highly informal even into the 19th century. Informal arbitration was also useful for family conflicts, and I've got a picture of particularly that here. A wedding at St Clement's Church in 1763, for instance, was interrupted by the elder brother of the groom just as the marriage ceremony was about to begin. He claimed the bride had already been promised to him. The clergyman officiating suspended the marriage until agreement was reached, and the brothers referred the dispute immediately to the arbitration of their friends, and they found in favour of the late arriving elder brother. He duly married the bride, although her thoughts on the matter are sadly not recorded, but the newspaper report insists that the whole company dined and spent the evening amicably together. Seems a little unlikely, perhaps. Family arguments over property, inheritance, wills, trusts, and annuities were regular occurrences, and all were frequently referred to arbitrators or mediators, and these were often friends of the family. Successful resolution was naturally not guaranteed, and family harmony could be the most difficult to restore. This, of course, comes with the caveat that arbitration was also a useful device to prevent a quarrel developing in the first place. As we've said, wills were frequently disputed, and the parties were of all stations in life, from those disputing the Duke of Newcastle's will in 1714 to ordinary people like the yeoman, husbandman and butcher in dispute over a farmer's will in 1794. There were women too among those of humble status who made wills. Anne West, a leather cutter's wife of Horncastle in Lincolnshire, included in her detailed will a clause appointing 2 local esquires to arbitrate any disputes. Lord Shelburne and his brother Thomas Fitzmaurice began litigation over some property of their late mother's, but the dispute was adjusted amicably by arbitrators in 1781. And real life in this case was also reflected in the theatre. In The Birthday, a play of 1799, twin brothers had a 15-year dispute over a garden inherited from their mother. One of their sons, who has legal training, manages to resolve their differences by acting as arbitrator. As we have seen, marriage, but also separation, were subjects of arbitration. In another case, a Mr. Mackrell, a farmer of Minchinhampton near Blandford, was an ageing bachelor who agreed to marry a widow who ran her own business. She quit her business in preparation for married life, but Mackrell then went on to change his mind. To avoid a lawsuit, they referred the matter to arbitrators, who awarded the widow £300, a large sum, but that was reported to be well within his means. However, the affair distressed him badly, and tragically he was found hanging in his cart house. The coroner returned a verdict of lunacy. There was little appetite in the courts for meddling in messy family disputes. In 1782, Judith Carroll sued James Falsfield in the Court of Common Pleas for £20 for the board and education of their 3 children. The case was complicated when the plaintiff's sister testified that 2 of the children died at 2 years old and that the couple had never in fact been married. To quote a newspaper report, the matter was considered of so delicate a nature that the court left it to private arbitration. In this age of widespread court reporting, arbitration could help maintain privacy, and there are no doubt many cases of arbitration and mediation within families of which no evidence survives. Now, arbitration was also an ideal solution to disputes in areas where rules were only beginning to emerge. And you may recognise this image from the front cover of the book. The boxing pioneer Jack Broughton introduced a set of 7 rules in 1743 for bouts at his amphitheatre in Tottenham Court Road, just round the corner from where we are today. And this became the basis of the code for most contests for over 100 years. Rule 6 stipulated that to prevent disputes in every main battle, the principals shall, on coming on the stage, choose from among the gentlemen present 2 umpires who shall absolutely decide all disputes that may arise about the battle, and if the 2 umpires cannot agree, the said umpires to choose a 3rd, who is to determine it, so using exactly the same procedure for a boxing match as merchants might. It was so important to be able to decide sporting contests because they often had large sums of money bet on them. This was a scenario in which parties actively wanted to stay isolated from the law. A fight in 1790 between the wonderfully named Big Ben and Hooper the Tin Man was supposed to take place on the quays at Newbury. The High Sheriff of Berkshire, along with the Mayor of Newbury, tried to prevent the fight, but the combatants laid out a ring 5 miles out of town at the Blackberry Common, which they reached by carriage along the Reading Road. Both men were hurt in the early rounds, after which an epic contest played out, and in the 131st round, Hooper was hit and fell. After this, the fight continued, apparently to round 180. Hooper kept going, but from this point without any blows being landed. Lord Barrymore, whose presence gives the suggestion of a crowd of aristocratic gamblers, stopped the bout and declared that it would be referred to arbitrators to decide, I think, the rather philosophical question of whether a man who kept falling without landing or receiving any punches could still be deemed to be fighting. Although there are many more anecdotes from the book concerning everything from gambling to religion, I'd like to end by considering the role of the arbitrator and the wider social value placed upon arbitration in the 18th century. I really think that submitting to arbitration was seen as a way to end a quarrel while preserving the honour and reputation of the parties. In a dispute between Edward Topham and C. Este, owners of a daily newspaper, The World, Este gave his adversary a deadline of 2 days to act, in which time he renewed his, quote, just and manly offer of arbitration. If he is not just and manly, I cannot help it. He must take the consequences. If some thought arbitration the manly solution to quarrels, it was also seen as a viable alternative to violence, which was an increasingly unfashionable, undesirable, and outmoded show of manliness. A letter was written to a newspaper by Arcadius, once again self-styled in 1773, calling duelling a Gothic custom. Arcadius recognised that, quote, there are many affronts and other intricate matters not cognisable by law, but he thought all of these might be solved by arbitration, or his suggestion for a new court of honour. Another article bemoaned the absurdity of the continuing practice of duelling, calling it barbaric and dishonourable. It acknowledged that a solution would be difficult, but suggested it would be a more rational method to refer the matter in dispute to arbitration by 2 or 3 friends on each side. A quarrel between 2 officers of the Derbyshire militia over payments for breakfast escalated apparently via a thrown handful of nuts to a challenge to duel. The situation was diffused then by the arbitration of a 3rd officer, proving the potential for the success of such an intervention. So, if agreeing to refer one's disputes to arbitration could be proof of good reputation and character, what about agreeing to act as an arbitrator? Certainly JPs regarded doing so as one of their duties, although some saw it as a service from which they sought to make money. However, the radical tailor and diarist Francis Place, pictured here, his thoughts on accepting payment for arbitration really are revealing, and he wrote in his biography, I gained much knowledge, and in many ways, and on many subjects, by these interferences, for which I never made any charge, unless the matter related to an association or large body of men. In some such cases, I have accepted a sum of money equal to that which the other arbitrators were paid. In 3 or 4 instances, where the parties were found to be rogues, or where the trouble was occasioned by bad feelings on both sides, I have made charges, as I did not think that rogues and evil-disposed persons had any claim on my time, because they had misbehaved themselves. Place's discomfort with the idea of arbitrator as a professional with a transactional relationship to the party or parties, combined with his understanding that it was a source of social standing, was shared by merchant arbitrators in Liverpool, who donated their fees to charity and then publicised that fact in the newspaper, presumably as a fillip to their reputation. These merchants normally donated between 1 and 3 guineas, although this fee was for each arbitrator, and in many cases 3 were required. Lawyers were increasingly involved in arbitrations in the late 18th century, and it could be good for their reputation too, which was then at rather a low ebb. Lawyers were portrayed in a more positive light if they were also an arbitrator. On the stage, 2 plays, The Birthday, which I've already mentioned, and the handily titled Arbitration, featured characters who were trained in the law, also acting as arbitrators. Both of these characters were clearly meant to be good, honest men, attempting to bring a just and speedy end to long-standing disputes. In The Birthday, another lawyer called Circuit is attempting to draw out a lawsuit to make as much money as possible from his client, in conspiracy with the client's housekeeper, so very much in contrast to the arbitrating lawyer. Purposeful delay and spiralling costs were frequent targets in satire aimed at lawyers both on and off the stage. In the above instances, lawyers acting as arbitrators were spared the usual criticisms and could even be the hero of the play. And on that note, I'll bow out with the closing lines of the introduction to the play Arbitration. It is left to you our merit to decide, by your kind arbitration we abide.
Thank you very much, Francis, for giving us that taste of some of the fascinating material that is in this book. A key theme to emerge from the book and from the research that has been done by both Francis and Rhiannon is really the debunking of this notion that courts are not supportive of arbitration and that judges jealously guard their jurisdiction. And perhaps we can blame Lord Campbell for peddling the myth that judges had a horror of arbitration, because this book really shows us a very different story. And there's a very nice section in it on Lord Mansfield. As we know, in his 30 years as Chief Justice on the King's Bench, he routinely referred matters to arbitrators. And it's fair to say that he comes across in this book as a real friend to arbitration. But it's not just at that sort of King's Bench level. And Rhiannon, I'm particularly interested in the fact that at all levels of the court, you see this real support for arbitration, and even in the lower levels, almost a deferential attitude and a real respect for the expertise and the sensitivity that arbitrators can bring to bear. Can you talk a bit about the research in terms of looking for those sources in the various court materials?
Well, obviously for the higher courts, we reviewed the English reports, which are fortunately all online. And we also searched the National Archives as the holders of records for the assizes as well as the higher courts. And unfortunately, the wealth of records we have are only touched on as catalogued items at the National Archives. But we went as far as we could on search terms like mediation, arbitration, negotiation there. From the English reports, using those three terms, arbitration, mediation, negotiation, we found over 650 references to look at. We just saw the tip of the iceberg from the National Archive, but did what we could with the records there. At the lower level, there's an increasing wealth of records available to search online at the local archives for quarter session papers and family papers which might be stored there. And so again, we made extensive use of searching across the country through quarter session records online. For unpublished law reports, we did rely on the work of other people. So Henry Horvitz and James Oldham on Lord Mansfield. James Oldham also on Lord Chief Justice Sir Selden Lawrence and Sir Peter King's Common Pleas reports. And John Baker, who writes greatly on English legal history, his work on English legal manuscripts. So those are the formal ones. As Francis has touched on, we looked at the notebooks of JPs across the country to add to our knowledge, not just of the quarter sessions, but the petty sessions as well. They sit in their living room and act in it on alone to see what we discover there. Other secondary sources, across the various archives, we found records of arbitration between many of the industrialists, such as Richard Arkwright, James Watt, Samuel Crompton, Thomas Telford. And because of the growing use of arbitration in businesses, someone like Lloyds Bank and their archive, we found a number of cases there in partnership agreements which include provision that any dispute is referred to arbitration there. Church courts is another one where there's an arbitration system. Anne Tarver is a writer on that, but Francis, I know, is more knowledgeable on that field, so I shall not mention any more. One area that I would like to know more on, but is difficult to search and find material on, are county courts, manor courts and borough courts. There is some secondary material available there, but for any budding PhD students, that is something that would really warrant more research. It's difficult to find the papers. There is nothing searchable. It's turning pages and looking, but I think there's a wealth of records to be found there.
Thank you, and you prompted me about the mention of religion and the sources of arbitration and religion. There is a chapter on religion and arbitration, and I was, which I understand was very much the work of Francis, and I was fascinated to read in it that the Quakers are described as probably the greatest advocates of arbitration in the 18th century, and apparently supported arbitration with quotes from the scriptures, so that extra legal dispute resolution was given divine endorsement. Now, a lot of arbitrators that we know think that they are God's gift, and it turns out that they might be right after all, if the Quakers were right. So perhaps you could just tell us a little bit more, Francis, about the Quaker approach to arbitration and the incredibly high regard that they had for the arbitration process.
Yeah, certainly the Quakers did kind of ground their belief in arbitration in the scripture, but then they took that onto a more practical footing just before the beginning of the 18th century and kind of promulgated a decree from the annual London meeting, which was kind of the most influential in Britain, setting out a full arbitration procedure and telling Quakers that they could be thrown out of their meeting, not only if they didn't agree to abide by the arbitration of others, but also if they didn't agree to act as an arbitrator. So they took that really seriously, both the kind of use of the process, but also interacting with it in every possible way. They kind of maintained this belief in arbitration throughout the 18th century, and that's been put down in part, that has been explained in part to be a grounding of their economic success. Certainly they did very well as traders across the Atlantic during that time. So I think that's really interesting as well, that there was a kind of real world outcome from both that religious but also institutional interaction with the arbitration process.
God and commerce working in harmony. So, I mean, I guess if one feels that the arbitration process itself is mandated by God, then that's also a very big incentive to abide by the award. But the question of enforceability in the 18th century is quite an interesting one. And the book does explore the sort of two approaches to that. One is the enforceability of the arbitrations, which arise and are sort of brought into the regime under the 1698 Act, and that's very much a sort of a Lord Mansfield style of arbitration referrals. But you touched on in your presentation, Francis, the informal side of arbitration as well. There's many arbitrations that we read about in this book where private individuals are just appointed to handle just disputes about land, family inheritance, gambling, lots of disputes over wages, sporting matches, and yet people abided by those awards. I mean, you talked about the fact that it was seen as a civilized process, in contradistinction to the litigation process or the barbarity of dueling. Were there other clues and this is a question for both of you, as to how it was enforceable how the informal arbitration was enforceable?
Yeah, I think there's a really interesting tension there between enforcement by punishment, like imprisonment, and then enforcement by the community. And I think, in a sense, the punishment wouldn't have really worked unless it rested on some kind of acknowledgement of the community valuing the process and valuing the enforcement of it as well. So I think in lots of communities, like Bolden that I was talking about earlier, or like within the Quakers, it was very much just the pressure of the community and the idea of being excommunicated, either whether that's religiously or socially, from your peers. That made it extremely forceful in a sense that didn't really need the courts to back it up. And then almost as an in-between. The bonds were there enforcing payment of money, but you wouldn't necessarily have to go to the courts to have that backed up, because I think a lot of the time people were so worried by the social implications to their reputation and honour that could be kind of just enforced merely by people's willingness to abide.
Now, Rhiannon, we see when we're looking at the court process system that it was not easy to complain about the court, and they were quite difficult to set aside. And just thinking of that, one of the other things that we see in the book is this notion that there is real freedom of parties to choose the arbitrator, not just in the informal arbitrations that we've been talking about, where people chose friends or fellow merchants, but also in the court, in arbitrations that have been referred to by the courts. We see, for example, in the shipping disputes, that whether they were brought before the Admiralty Court or the Navy Board or Chancery or Queen's Bench, they were all likely to end up, or many of them ended up in front of arbitrators. And although the court appoints the arbitrators, they were often arbitrators chosen by the parties. So I'm wondering, certainly the sort of pedigree of party choice we see very much in the sort of 18th century phenomenon, but we also see at the same time parties not being able to complain about the result. Do you see a link? Because these are two things which also are very modern for us. Party choice and also not being able to set it aside that easily.
The parties would have to agree to arbitration. It couldn't be imposed by the court. Therefore, having agreed, it was part of the arbitration agreement then was that that decision would be binding. And while the arbitrator would then reach their decision, and it would go to court to have that order enforced, and you will see the phrase, if the court shall so think. There's rarely an example where the court didn't go with what the arbitrator said. They didn't question that, it happened. And there was no right of appeal from arbitration as a general term of the court. And as Chief Justice Holt said in a case in 1795, because the arbitrators were judges of the party's own choosing, the losing party could not come back and say to the court they had not received justice and ask the court to examine that decision. Holt says, the integrity of arbitration, whom the parties by consent have chosen to be their judges, shall never be arraigned. You've agreed to do it, you will abide by it. It is that way of stopping the 10, 20, 30 years in Chancery. You go to arbitrators to end it, and once you've agreed to it, then it ends.
Yeah, I think to have a decision overturned, you really had to, it had to be beyond competent. It had to have kind of really some sort of element of illegality or
corruption. I'll be throwing it open to questions, I think, from the floor there. I noticed a couple of avid theatre goers in the audience, and there is also a rather delightful part of the book that deals with and explores the prevalence of arbitration to resolve disputes within the world of theatre. In fact, the book goes so far as to say, I quote, "There can hardly ever have been at any time or place a more disputatious lot than those involved in the English theatre in the 18th and early 19th century." So, Francis, tell us about your favourite theatre arbitration.
I think there's so many because, as you say, there were just so many erratic personalities involved. Some more famous, like Robert Brinsley Sheridan. All of them really kind of had problems with a lot of basic skills like timekeeping. So I think that was part of what made them so infuriating and made them so disputatious. Probably my favourite was regarding the Covent Garden theatre riots in the early 19th century. Just the idea that you would go out and riot because the cost of a theatre ticket had been changed, I think, is kind of quite alien to us today, but people really did that. And the whole thing became quite performative. The arbitration too became something of a performance, with the manager of the theatre going out on the stage and pleading with the crowd to stop rioting, saying that he would take the whole thing to arbitration. And then when he did so, it wasn't deemed to be suitable by the audiences, who continued to riot out in the streets, because he'd chosen all the arbitrators and they weren't given the opportunity to do so. So there was still this sense that the process should be adhered to just as it would be between two normal people. And it was only when he actually sat down and met with one of the lead protesters at a dinner that they managed to kind of mediate the dispute. And the manager was then still forced to come out on stage the day after the riots end and kind of grovel a bit and say that he compromised and promised not to do it again. So yeah, just some really wonderful stories of those theatre disputes.
Thank you. Well, let me throw it open to the floor. You have two leading experts on the 18th century arbitration world here.
So obviously in our own day, the age of arbitrators has come under increased scrutiny. And I know that in the 18th century, the legal system, but also society generally, has been described as very gerontocratic. And I wondered if you had any comments on the age of arbitrators and the resources that you looked at.
Really interesting question. We didn't look specifically at age at any point.
I don't think it was mentioned.
Yeah.
I'm looking at the picture. Well, I'm wondering when he started.
I think for merchants, as soon as they were kind of professionally looked up to, as soon as they were succeeding, they would have expected to act as an arbitrator. So for professional men, not necessarily something that they came to particularly late. I really think it was just when you had a kind of flourishing business. The arbitrator would generally be someone of slightly higher status than them, or at least equal status to the people referring to them. So I'm not sure if anyone's ever done a study of the age of judges in the 18th century, and I imagine they were probably tending to be getting on a bit, although not necessarily quite as aged as Francis Place there. But certainly in his autobiography, he talks about arbitrating at a much earlier age than he was then. So his successful business life, he retired quite early, so he would have been arbitrating as an active businessman. So he probably would have been involved in his 30s. So I'm not sure that necessarily acting as an arbitrator was quite the gerontocracy it could have been, but because it wasn't limited to the legal profession, and there was very much for active merchants.
Rhiannon, did you find any women arbitrators in your research?
Not in my research, but while we were talking, I had a sudden Jane Austen moment. And for anyone who's read Pride and Prejudice, and the rather obnoxious Lady de Vere, I think, is the senior member of society there. And in that, she boasts of what she does in the community. And one of those things is to act as arbitrator. And that word is used in Pride and Prejudice. Women appear as parties, plaintiffs or defendants in the cause. They appear as single women or as widows. The only time we generally found married women is if they were acting with their husbands. It's very very rare to find a woman, a married woman, acting alone. But there was one exception, and I think I've got a reference to it. Yes, a lady called Arabella Beard, and she'd been separated from her husband for some time. But she carried on a business in the City of London. She fell into debt, and the gentleman who was the creditor wanted to enforce payment, and the matter was in dispute. And Arabella Beard claimed, as a married woman, she claimed that she was a femme covert, and that her husband should actually pay her bills. It came before Lord Kenyon, And he said, no, women commonly act in business on their own and you can pay your own debts. And that matter then on the damages and the cost to be applied was referred to arbitration. But otherwise we see women, there's quite commonly then if it's a widow and she's executrix of her husband's will, there's any dispute on that, that might go to arbitration. We found an example in the Norfolk county record offices of a dispute between a brother and sister about the management of the family farm. And in that instance, it's reported that the married sister acted as a mediator in the dispute between them, but we didn't see the word arbitrator for a woman, apart from Jane Austen. So Jane Austen actually mentioning it suggests that as almost a female justice of the peace in her own way, that certain women in society may have a more influential role than is written for us to now to find, as Francis said, is hidden and unwritten records somewhere.
Yeah, I think we were particularly frustrated by that in a way, because we do know that women acted as arbitrators in earlier times, and there are records of that. Always women of fairly high society, kind of aristocratic women. So I think we were maybe expecting to find a little bit of that carrying on in the 18th century, but it's quite interesting that really, well, it certainly wasn't recorded. So yeah, that was one of the surprising things.
Other questions?
Okay. You earlier raised that you found from your research that the Quakers had sourced their ideas of ADR from religious text. Would you be able to tell us what sort of text they got that from? And if as I'm assuming, it was from the Judeo-Christian text, whether or not that wouldn't have been mediation rather than arbitration, given the references in the Judeo-Christian text mainly to mediation, and it's difficult to find anything on arbitration as such. Could you enlighten us more on that?
There's an excellent paper by F. Peter Phillips that gives you the scriptural references, I believe, that they did use. I think someone might be able to correct me, but I think it was George Fox who kind of initiated the Quaker movement. And he he certainly made biblical references to support his beliefs in arbitration. But then I think it was his backing of arbitration that was generally referred back to by later Quakers when they were kind of instituting formal arbitration processes.
Yeah.
So I think when it was becoming formalised, they didn't necessarily refer back to scripture themselves, but he certainly saw arbitration being supported by the Bible, but I'm not sure that he actually picked up on the word being used. He just felt that the spirit was there.
Because there are papers written on that, particularly in Canada and the USA, showing the specific references. In fact, there's been a recent article in 2017 looking at the Greek word nesites, which is the Greek word for mediator. So,
well, the Peter Phillips article that was just mentioned by Francis is in the 2016 Journal of Dispute Resolution.
Brilliant, thanks.
On the matter of trade disputes, well, during the period in question, there was a ferment of trade, commercial relations and trade in the colonial nexus, and I don't know whether I sort of did pick it up, but I didn't see much reference to matters of trade disputes and settlements, so especially in the context of the East India Company and generally, but it's, I think, confined mainly to the ambit of Britain. I just wonder whether it's in the book or you haven't gone that far in the exploration.
Well, I think we purposefully couldn't really widen our searches out to international trade and the kind of colonial context. I think there's a whole other book to be written there, because it certainly did happen a huge amount. And I've read really interesting papers about the East India Company and the ways that it used arbitration, particularly in colonial India, but also in other contexts. So, yeah, certainly there's a huge amount there. But,
yeah, but we're talking about 18th century, so the 18th century is sort of, it extends beyond the boundaries of Britain.
Well, absolutely, and I completely take the point. It would be wonderful to go on to do some research about kind of arbitration through the colonies, but I think it would have turned that into 2 or 3 volumes rather than 1. So.
If anyone here wants to sponsor it, of course, then I know that Carl will be very happy to talk to you. Do you have another question at the back? Thank you.
Yes, I heard some reference, I think I saw it in the book, to arbitration about wagering, and that threw up in my mind the question of was there a concept at all of any subject matter being unarbitrable? Were there certain topics which you couldn't arbitrate about? Or was everything fair game?
Everything, I would.
I think essentially if people agreed to arbitrate on it, then it was arbitrable. There are some later commentators that said that land wasn't an arbitrable matter, but they seem to have been very much proved wrong by practice. So even though there were certain things that legal scholars said couldn't be taken to arbitration, people had other ideas, and I think if both parties agreed on the arbitration and were willing to stand by it, then really that was all that mattered to them.
Other questions? Yes.
Was there any arbitration about the ownership of people? I was thinking of children really, but then I thought about slaves as well.
Children crop up in records when there are family disputes and inheritance and the like, and those cases are difficult to follow because for as long as a child is a minor, it cannot be a final decision in the case. There is not a final order. That part relating to the child carries on because at some point on reaching its maturity, that the 21, that the child can come back to court and say they're unhappy with the way something has been dealt with. So, yes, there are instances of arbitration, but you do not find a final answer in the court order book. In the records in Chancery in the National Archives, you have the rolls with the depositions and the bills and balances, etc. And there's also a set of books which are the decrees and orders. And a former colleague of mine who's here and has just recently retired from the National Archives, we spent many days trying to explain to people how to use the decrees and order books. But they're kept by the term in an alphabetical listing, and there is no catalogue to it. You just have to look for, it can be the first name of the plaintiff, first name of the defendant, Smith v. Jones, Smith v. Evans, Sampson versus whatever, and you just go look and then hope you will find an order. And I've spent many hours following a Chancery case through for the book and looking through the decrees and orders. And when it comes to a child, I'm thinking, I can't find the one saying this is the final order. And I realise it's because there's children involved. And so long as that child can come back and question it, you do not find something telling you this is the end of the dispute. So it's very frustrating to work with.
Also, coming back to slaves, certainly we came up with a few cases where people sued for damages after a ship had been lost traversing the Atlantic, and sometimes the cargo would be slaves, so then an arbitrator might have to put a price on the human cargo that had been lost.
I've done a lot of work with the High Court of Admiralty papers, and arbitrators are used regularly to work out the value of the prize, and slaves are a commodity commonly there to be valued.
Other questions?
In later times, both in earlier and later times, we see the courts or people trying to establish cheaper modes of litigation, and the party is, I guess, the county courts of Middlesex. The county courts of Middlesex, and in medieval times, various initiatives about free counsel. Over your period, is there any competition for cheap litigation, or is arbitration, has it kept the field?
Things like the petty sessions coming in certainly made some difference. I think a lot of the concentration in that area was over small debts. So there were lots of cases of people like the Sephardic Jews in London certainly kind of ran what was essentially a small debt arbitration court for themselves, and the petty sessions and courts of requests, I think, as well, where I suppose in some sense competition to arbitrators over small debts. I think arbitrators generally found themselves so sort of overwhelmed with business and didn't often charge until later in the century, or indeed unless they got huge numbers of cases. So I'm not sure that it was really seen as competition for them when they were really just doing something that they were expected to do for their local community. Maybe apart from the example of Middlesex, where they did have trading justices who were given so many references to arbitrate that they did start charging and were using that as a way to make a bit of money on the side. But they were really seen as, there's a quote from Edmund Burke, that's something along the lines of them being the scum of the earth. So they weren't certainly seen very well for doing it. So.
Time for one more question.
Thank you. You showed the picture of the printed guide for apprentices on the screen.
Yeah.
Was there any other kind of printed literature by way of guidance? And did Stuart Kidd sort of fill a gap in the market with his treatise on the law of arbitration at the end of the 18th century?
Certainly there were a couple of earlier books on arbitration, kind of setting out the full law. They seem to be aimed very definitely at lawyers, and there were a few more like this one, and this went into quite a few editions, kind of setting out a much simpler method of arbitration, but without any particular legal background. So I think in that sense there were almost two markets. One, the learned market of lawyers that Kidd was catering to, that wanted to know all about the precedents and the law, and then these kind of trade directories where people were very much giving a sort of practical guide to exactly what you needed to do, and had the kind of printed forms and things like that. So yeah, two very different kind of markets for that sort of thing, both of which were reasonably well catered for, but the legal market much more so later in the century, as you say. I'm not sure if you...
Okay, well, I will hand over to Carl before we close, but may I just express my thanks to Francis and Rhiannon for their contribution and for this amazing book. And in thanking them, please remember that Derek and his lovely wife Susanna Ho will be able to hear your applause on the video. So we're also saying thank you and well done to Derek, not just for this book, but for all of his amazing books that have brought to life the history of arbitration and mediation. So thank you both, and thank you Derek and Susanna.